Hello everyone, my name is Ashish Kumar Pathak. I am a second year law student and I am currently doing my internship at ubAdvocate. In this video, I am going to talk about the Mediation Bill 2021. This bill was introduced in Rajya Sabha on December 2021 and the main aim of this bill is to promote mediation, including online mediation. This term mediation is mentioned in some specific laws such as CPC, Companies Laws, or Consumer Protection Act, but there is no standalone legislation on this topic as yet. Now, before understanding about this bill, we need to understand a term, alternative dispute resolution, also known as ADR. ADR refers to any means of settling disputes outside of the courtroom. In ADR, we use a natural third party who helps the parties to communicate, discuss the difference, and resolves the issue. There are mainly four types of ADR. First is arbitration. The parties that submit their dispute to an arbitral tribunal who makes a decision, which is known as award, and this award mostly binding on the parties. Second is conciliation, a non-binding procedure in which an impartial third party who is known as conciliator assists the parties to a dispute in reaching a mutually satisfactory agreed settlement of the dispute. Third is mediation. In this, we also use a impartial person called as mediator who helps the party to try to reach a mutually acceptable resolution of the dispute. The mediator does not decide the dispute but only helps the party to communicate so that the parties can try to settle their dispute themselves. Fourth is negotiation. This is most common type of ADR, a non-binding procedure in which discussion between the parties are initiated without the intervention of any third party. Now, applicability of this act. This bill will apply to mediation proceeding conducted in India. First, where all parties residing, incorporated, or have their place of business in India. Second, the mediation agreement states that mediation will be as per this bill. Third is there is an international mediation, which means mediation related to a commercial dispute where at least one party is a former government, a foreign national resident, or an entity with its place of business outside of India. Now, in these cases, if one party is central or state government, then this bill will not apply except where the dispute is of commercial in nature. Pre-litigation mediation. In a party must try to settle their dispute by mediation before approaching any court or certain tribunals as notified. Even if the parties fail to reach a settlement through pre-litigation mediation, the court or tribunal may at any stage of the proceeding refer the parties to mediation on their request. This will apply only on cases of civil or commercial dispute. Now, there are some disputes which are not fit for mediation. First is relating to claim against minor or person of unsound mind. Second, involving prosecution for criminal offenses. Third is affecting the right of third party. And fourth is relating to levy or collection of taxes. Mediation process, the procedure of mediation. Mediation proceeding will be confidential. A party may withdraw from mediation after the first two sessions. This whole process must be completed within 180 days. This may be extended by another 180 days on the request of the parties. Now, mediators, which is an impartial third person. Mediator only assists the parties to settle their disputes and cannot impose a settlement on them. Mediator may be appointed by the parties by agreement or a mediation service provider. Now, Mediation Council of India. The central government will establish the Mediation Council of India. This council will consist of 7 members, one is chairman, two full-time members with experience in mediation or ADR, three ex officio chairmen, including secretaries in the Ministry of Law and Justice and Finance, and one part-time member from an industry body. Function of this council include registration of mediators, recognizing mediation service provider, training them, educating them, and certification of mediators. Now, mediated settlement agreement. Agreement resulting from mediation. After the parties settle their dispute, they must make an agreement, and that agreement must be signed in writing by the parties and the mediator. Such agreement will be binding and enforceable in the same manner as court judgment. Mediator settlement may be challenged only on the ground of fraud, corruption, impersonation, or relating to dispute not fit for mediation. Thank you, everyone.